If you think back to the testimony of Nicholas Kirby, he felt bad for threatening Mr. Brooks, like somehow this was his fault. He was just trying to be there for his friend, someone he recently met. So Mr. Brooks, that other act's evidence is a very clear indication of your poor moral character. It demonstrates unequivocally that you have absolutely no remorse for anything that you do. You have no empathy for anyone, and that you are justified in the actions that you take. In addition to that conduct, as part of your character, this court is able to look at and consider your prior record. And I'm well aware, sir, that you're raising an objection sign, but you have forfeited your right to be here, and I will not stop, and you will not be brought into this courtroom. I will continue. This is his prior record, going back to two thousand, spanning what? Nevada, Georgia, at least police contact in Georgia. We have an unknown disposition in Wisconsin. Substantial battery in 2000, party to a crime. Put on probation, ultimately that was revoked, he went to prison. 2002, felony possession of THC, jail time. 2003, resisting obstructing, jail time. 2005, a disorderly conduct ticket, but he failed to pay the forfeiture and ended up serving an alternative to incarceration. He ended up serving for failing to pay 30 days jail. 2009, obstructing, 2 days jail, meaning he lied to police. 2010, strangulation. Battery was dismissed and read in, put on probation, ultimately revoked, serving 11 months jail. 2012, misdemeanor bail jumping, possession of THC, with a number of other charges being dismissed and read in, 180 days jail concurrent. Also in 2012, a misdemeanor resisting or obstructing, so either he lied or he fled from police or did something to make their job more difficult, 37 days jail consecutive. In Nevada in 2006, domestic battery, a suspended sentence, obstructing after being found guilty at trial, for which he served jail time. 2007, statutory sexual seduction as a felony. This is for impregnating Erica Patterson when she was a minor. 2016, charged with not being in compliance with the sex offender registry requirements, for which there is an outstanding warrant. In Georgia, a 2021 arrest for battery, domestic violence, presumably with Erica Patterson based upon where she came from at that time. But I won't make, I say presumably, but frankly doesn't matter who it was with. We also know that there's the 2003 paternity case out of Waukesha County. Why is that relevant? Because 8 times during that case, a warrant has been issued for contempt of court, meaning for failure to pay his financial obligations to a child or children. The pending cases for which one pending case, I should say, he was, I don't believe, charged with bail jumping for that one. The 20 CF 2550, 2 counts of recklessly using a weapon, felon in possession of a firearm, released ultimately in March of 2021. He's accused in that case of firing a shot. There were two occupants in a vehicle. One was his nephew, and when he was picked up by police, a loaded Beretta, 9mm, which had previously been reported as stolen, was found in his possession. I already talked about the other acts evidence, that is for which he was charged with felony bail jumping, the second-degree recklessly endangering safety for allegedly running over Erica Patterson, the battery DV, DC DV, and a resisting obstructing. And then the second would be he was charged with intimidation of a victim, felony bail jumping for conduct on November 8th. So November 2nd, November 8th. This is clearly someone with a demonstrated violent history and past, someone who has absolutely no regard for anyone but himself. To say that he is a lifelong criminal, I think, is accurate. He disobeys law enforcement, he disrespects court orders, and he certainly demonstrated that he has no respect for these proceedings. Multiple acts of violence, violent, dangerous behavior that predated the attack on the Waukesha Christmas parade. His character, or lack thereof, is also demonstrated by his complete and utter denial of culpability in this case. His blaming of his mental health or alleged mental health. There's no evidence that he was suffering from a manic episode. I went through all of that earlier today, going through the 4 reports related to the special plea. None of those doctors found support for his special plea. Mr. Brooks talked about, at times, this being the will of God, or that all things happen for a reason. I'm here to tell you, Mr. Brooks, you are not an instrumentality of God. Death may be inevitable to all of us, but you cut the lives of 6 individuals short. You alone, Mr. Brooks, cut the lives of these 6 innocent people short. I talked earlier about how I believe he's intelligent, deliberate, and purposeful in what he does. I've considered that you have treatment needs. Perhaps there are intersecting mental health issues as it relates to your personality disorder, but those issues can best be addressed in a confined setting where the Department of Corrections will be charged statutorily to evaluate you and to provide any medical or mental health treatment that you need. This is a case that falls squarely on the need to protect the community. I referenced this earlier. There's really 3 primary reasons for the sentences I will impose here today. One is punishment, one is to protect the community, and the other is to provide justice and closure to the victims. Because under that category of need to protect, the court does get to consider the impact of these crimes on the victims. I went through at length in reviewing all of those victim impact statements. I certainly didn't go through every single one, just highlighting some of them, but doing so with purpose, because it is very clear to this court that Mr. Brooks has caused carnage, mayhem. It has resulted in many people suffering from PTSD, from mental and emotional trauma that will take a lifetime to recover from, and for some, perhaps, if at all. You have taken away from these individuals future memories. They will never have birthdays with the 6 individuals who were killed. There will be no weddings. There will be no graduations. There will be none of the milestones that these families were looking forward to, whether it be for an innocent 8-year-old or an innocent 79-year-old. Frankly, Mr. Brooks, no one is safe from you. This community can only be safe if you are behind bars for the rest of your life. The actions of Darrell Brooks demand punishment. The community is not safe from your violent and criminal conduct unless you are in custody. You left a path of destruction, chaos, death, injury, confusion, and panic as you drove 7 or so blocks through the Christmas parade, never once stopping or seemingly caring about the wake of carnage that you left. 4 of those blocks were turned into a scene that frankly is no different than a war zone. On counts 1 through 6, this court is imposing a life sentence without the possibility or eligibility for extended supervision consecutive to one another. 1 life sentence for Virginia Sorensen. 1 life sentence for Leanna Owen. 1 life sentence for Tamara Durand. 1 life sentence for Jane Kulik. 1 life sentence for Bill Hospel. And 1 life sentence for Jackson Sparks. I've considered the enhancer and the additional 5 years that I could impose, but I don't need to really order that because I've not made him eligible for extended supervision, and it would only be to increase his time on initial confinement. But make no mistake, Mr. Brooks, you use that vehicle as a battering ram, no different than, frankly, a firearm. On counts 7 through 67, these are 61 counts of first-degree recklessly endangering safety. These charges alone and these convictions without the enhancer carry a maximum of 12.5 years. Because of the enhancer, a total of 17.5 years. And under Wisconsin law, the 5 years is added to the initial term of confinement. So what could be 7.5 years is a maximum of 12.5 years. And I'd ask that everyone no longer show any reaction to the sentence so I can get through this. On counts 7 through 67, on each count I will impose a total sentence of 17.5 years. 12.5 years of initial confinement, plus 5 years of extended supervision, consecutive to any other sentence that I've imposed here today. That is 762.5 years of initial confinement and 305 years of extended supervision on top of the life sentences that I've imposed. That is 17.5 years, sir, for Nicole White. 17.5 years for Eleanor Anders. 17.5 years for Sasha Catalan Castillo. 17.5 years for Maura Gilchrist. 17.5 years for Justin Gullickson. 17.5 years for Harry Guilfoy. 17.5 years for Aiden Lofgren. 17.5 years for Theo Maza. 17 and a half years for Tyler Pudliner. 17 and a half years for Connor Tank. 17 and a half years for Eric Teagues. 17 and a half years for Adelia Maffioli. 17 and a half years for Kelly Graybow. 17 and a half years for Josh Craner. 17 and a half years for Riley Rogers. 17 and a half years for Caden Rogers. 17 and a half years for Tucker Sparks. 17 and a half years for Isabella Bartlett. 17 and a half years for Yaritzi Becerra Montez. 17 and a half years for Samantha Coelho. 17 and a half years for Madison Hollingsworth. 17 and a half years for Mackenzie Hollingsworth. 17 and a half years for Mitchell Lampine. 17 and a half years for Kathleen Pielmeyer. 17 and a half years for Julia Schleichow. 17 and a half years for Olivia Stover. 17 and a half years for Jennifer Stover. 17 and a half years for Jesselyn Torres. 17 and a half years for Alice Urell. 17 and a half years for Charlotte Urell. 17 and a half years for Vivian Urell. 17 and a half years for Grayson Urell. 17 and a half years for Lola Hospel. 17 and a half years for Tamara Rosentreter. 17 and a half years for Betty Strang. 17 and a half years for Maria Alvarez Dominguez. 17 and a half years for Gregoria Romelia Perez. 17 and a half years for Elliot Hallmark. 17 and a half years for Benjamin Hallmark. 17 and a half years for Patrick Heppy. 17 and a half years for Lori Locken. 17 and a half years for Marisol Lopez Gutierrez. 17 and a half years for Adair Lopez Rubelar. 17 and a half years for Juan Marquez. 17 and a half years for David Marquez. 17 and a half years for William Mitchell. 17 and a half years for Jason Petchloff. 17 and a half years for Margaret Pachulis. 17 and a half years for Yamilet Perales Alvarez. 17 and a half years for Island Perales Alvarez. 17 and a half years for Ashley Perales Alvarez. 17 and a half years for Jose Perales Alvarez. 17 and a half years for Maria Perez. 17 and a half years for Camila Perez Gonzalez. 17 and a half years for Isaac Foglia. 17 and a half years for Deborah Ramirez. 17 and a half years for Charles Green. 17 and a half years for Lily Green. 17 and a half years for Brinley Harris. 17 and a half years for Kelsey Knapp. 17 and a half years for Owen Ricciati. On counts 68 through 73, which are the 6 counts of hit and run resulting in death, these are 25-year felonies each. The court will do the following. On count 68, a 25-year total sentence, 15 years of initial confinement, 10 years of extended supervision. This will be concurrent to count 1. Count 69, the same sentence, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 2. Did I say that the right way, the first one? Okay. Count 68 is concurrent to count 1. Count 69 is concurrent to count 2. Count 70, 25 years total, 15 years of initial confinement, 10 years of extended supervision, concurrent to count 3. Count 71, 25 years total, 15 years of initial confinement, 10 years of extended supervision concurrent to count 4. Count 72, 25-year total, 15 years of initial confinement, 10 years of extended supervision concurrent to count 5. And on count 73, a 25-year total sentence, 15 years of initial confinement, 10 years of extended supervision concurrent to count 6. On count 74 and 75, the 2 felony counts of bail jumping, the court is ordering a 6-year sentence total on each count, 3 years of initial confinement, 3 years of extended supervision, consecutive to all other counts but concurrent with one another. And lastly, but certainly not least, the maximum sentence for the battery to Erica Patterson, 9 months consecutive to any other sentence. To order anything other than what I have done, sir, would be to unduly depreciate the seriousness of these offenses. It is needed, although largely symbolic, given the number of years that I have imposed here today, because frankly, you deserve it. I know it's symbolic, but it needs to hold you accountable in a very real and tangible way. For all of these sentences that I have imposed, I will order the following conditions: no contact with the victims as identified in the amended victim key or their families, no contact of any kind with Erica Patterson. You are to pay restitution in the amount of $47,193.29 to EMC Insurance Company, that's on behalf of the Waukesha School District, and $124,000, $220.65 to the Crime Victim Compensation Program. I am ordering DNA surcharges on all counts. On counts 1 through 75, it's $250. On count 76, it's $200. Those are mandatory under the law. I'm also imposing the domestic abuse surcharge on count 76 of $100. I'm also imposing all standard court costs on all counts, although my primary emphasis is that restitution be paid before costs, surcharges, and fees. I will order that restitution, costs, and fees be paid out of prison money. In other words, that all financial obligations shall be collected pursuant to statutory provisions as requested by the state. That's frankly a standard, it's customary. But it will be in the judgment of conviction. And then pursuant to 949.165, I'll find that it is appropriate for this court to order an escrow account under 949.165 for payment of restitution, costs, fees, surcharges, and even for costs associated with prior legal representation or future representation under the statute. Mr. Brooks has been convicted of a number of serious crimes for which this section is appropriate. I will order 360 days credit as to count 1 and count 68. Only all other counts, 0 days credit because of the consecutive nature of the sentences that I've imposed here today. I calculated that with my sentence calculator. Of course, that is through yesterday because these sentences commence today. There are a number of advisements I must go through. First of all, Mr. Brooks will be provided with a written explanation of determinate life sentence regarding the first-degree intentional homicide charges. Of course, he's not eligible for release to extended supervision. That form defines extended confinement for him, and there's other language on here that he can read at his convenience. He also will be provided with the Notice of Right to Seek Post-Conviction Relief form. The court will fill out the caption for him. He is instructed to review it and review the defendant's acknowledgement, make the appropriate selection, sign and date it, and return that to the court. I must advise you, sir, you have been convicted of a felony. That means you may not vote in any election until your civil rights are restored. You may not possess a firearm. You may not possess body armor. Both of those are punishable as felonies. You also have 20 days from today's date to appeal the decision of this court. Does the state believe I've overlooked anything here today?
No, thank you, Your Honor.
All right, those documents will be provided to Mr. Brooks. I will note for the record, at many times during my final sentencing remarks, he was holding up an objection sign. That objection is noted for the record. This now concludes this hearing and this case. We are now off the record.
Do you want to do the motion to stay pending appeal, or we could do it another day?
I want to wait till I sign the judgment of conviction.
Okay.
I'm not making any determinations regarding where he is to be held. That certainly is within the, once the judgment of conviction is signed, I'll address the motion for stay pending appeal. But my understanding is he needs to be transported to Milwaukee, and I will not stand in the way of that. All right, I'll schedule that once the judgment of conviction is signed.
Understood.
We are in
Thank
recess.
you. Okay.
Thank you, everyone.